marks a historic milestone for United Proud Women as we host our first ever legal expert, Mr. Gerhardstein, the legendary civil rights attorney. For over 40 years, Mr. Gerhardstein has litigated causes, not just cases, with a central focus on achieving true systemic change and dismantling the structures of oppression, a philosophy that deeply resonates with our mission as sexual minority women navigating intersectional challenges. Today marks the 10th anniversary of one of his most critical victories, Obergefell v. Hodges, the landmark gay marriage case. The journey that culminated into a historic civil rights victory began with a single heartbreaking injustice chronicled in the book Love Wins, The Lovers and Lawyers Who Fought the Landmark Case for Marriage Equality, available on Amazon. Jim Obergefell and John Arthur were a devoted Cincinnati couple who had been together for more than 20 years. When John was terminally ill with ALS, a progressive neurodegenerative disease that affects nerve cells in the brain and spinal cord, leading to loss of muscle control, they flew to Maryland in 2013 to legally marry on a medically equipped jet. However, upon returning home, the state of Ohio refused to recognize their union, meaning Jim would not be listed as John's surviving spouse on John's death certificate. It was his final crude denial of dignity, a promise made to a dying man who wanted to be remembered as married, that Mr. Gerhardstein took on. Mr. Gerhardstein recognized the legal opportunity to challenge state bans on same-sex marriage after the 2013 U.S. v. Windsor decision. Crucially, he pursued the case even when the ACLU and other advocates expressed concern that losing the case would set back the movement for decades. Mr. Gerhardstein took on the case and argued that refusal to recognize Jim and John's out-of-state marriage violated the U.S. Constitution. His legal strategy propelled the suit, which grew to include other plaintiffs up through the lower courts and all the way to the Supreme Court, making it the most significant gay rights case in the U.S. history. That case became the 2015 U.S. Supreme Court decision, established marriage equality for same-sex couples in all 50 states. Mr. Gerhardstein's commitment to civil rights extends far beyond marriage equality, defining a 40-year career dedicated to achieving systematic reform. He has driven institutional change in various areas, including but not limited to securing major police reforms and the adoption of body cameras after representing families of police misconduct victims, advocating for reproductive health as general counsel for Planned Parenthood, and securing extensive reforms for youth committed to the Ohio Department of Youth Services. His career demonstrates a relentless dedication for human dignity and lasting, tangible change. Mr. Gerhardstein's history of civil rights litigation will be featured in a soon-to-be released Netflix documentary titled Amend the 14th Amendment and the Story of Inclusion. He has also been interviewed and quoted extensively in national and Ohio media and has taught civil rights litigation at Northern Kentucky University's Chase College of Law and the University of Cincinnati. Today's talk, Queer Rights, Hope or Despair, Finding Avenues for Action, speaks powerfully to our current moment. The precarity of LGBTQ rights today is underscored by the fact that former Kentucky clerk King Davis is attempting to convince the Supreme Court to overturn the Obergefell v. Hodges by challenging a civil judgment against her on religious freedom grounds, alongside ongoing legislative and policy controversies regarding the inclusion of transgender women athletes in California school sports and beyond. As sexual minority women who refuse to be challenged, who build community in defiance of invisibility, and who organize for change despite formidable oppression, we need both the unflinching clarity to confront the challenges before us and the strategic wisdom to move on. Please join me in extending a warm, united woman welcome to Mr. Gerhardstein, a steadfast ally and true accomplice in our shared struggles for dignity, autonomy, and justice. Welcome.
Well, thank you, Carlin. That was a wonderful introduction, and I appreciate all the work that all of you are doing as you pursue equal rights across the world. What I would like to do today is two things. Number one, my first goal is to give you an accurate assessment of my view of the status of gay marriage in the United States. And then secondly, to review some of the assaults that have been pursued against LGBTQI rights in the United States as well, more broadly. So let me do that with a set of slides that should help our discussion. So, as Carolyn said, I represented Jim and John. Jim Obergefell is on the left, John is on the right, and that's Aunt Pauline up in the middle. She was John's aunt, and she married them on the tarmac in Baltimore on July 11th, 2013. And John, of course, was suffering from ALS, and they needed an accessible place. They had a medical jet. Friends had helped them put it together. They got married. They couldn't stop using the word husband. They were happy as could be. Prior to that time, what encouraged them was Edie Windsor. Edie Windsor had just prevailed in the case of United States versus Windsor. And she had married Thea Spaya in 2007 in Canada. And in the state of New York recognized her marriage as valid as a same-sex marriage in 2007. And then her spouse, Thea, died in 2009, and Edie Windsor was forced to pay a federal estate tax of hundreds of thousands of dollars. The only reason that Edie had to pay that estate tax was a law that had been passed during the Clinton era, which was the Defense of Marriage Act. And Section 3 said the United States of America would not recognize same-sex marriages. This was incredibly unusual. The United States had never weighed in as a federal government on which marriages were valid and which weren't. They always just accepted the states. But in DOMA, they had drawn this line, and Edie challenged it. And then the case was decided by striking down the Section 3 of DOMA and saying, no, the United States really has to return to its old practice of deferring to states, and it should not, pick and choose between which marriages it will recognize and which it won't. And the Supreme Court held it unconstitutional. So this was a very big deal. And I read it in Ohio, and I thought, my goodness, that means that Ohio, like the federal government, should recognize same-sex marriages from other states. At the time, there were 9 states in the United States that recognized same-sex marriage. And I also knew that there were various ways in which recognition would be important. I had done a lot of civil rights cases involving people who had been killed by the police and others where somebody had died. And in my experience, we used and had to refer to death certificates. And on these death certificates, which you see, and I'm sorry it's so small, but section line 10 asks for the marital status of the person who died and the name of the surviving spouse here at line 11. And when a friend of mine introduced John and Jim to me, I had to remember that this is how they would be impacted. That in fact, Ohio would not recognize their marriage from Maryland, even though they had gone to this tremendous trouble to go and get married. because Ohio had a constitutional amendment to our state constitution. And that constitutional amendment said that marriage could only be by between a man and a woman. And therefore, they would not be recognized at the time of their marriage. So I met with John and Jim, and John was dying. He was very close to his final days. He was in a hospital bed in their condo. I could totally understand if they chose to just use their final days together to say goodbye. They had no reason to take on this struggle. But I said they did have standing. They had the right to challenge Ohio's constitution and say that it violated the federal constitution in light of the Windsor decision. And if they wanted to do that, I'd be willing to represent them. They took a few seconds to consult, and they decided yes. They wanted to challenge Ohio's failure to recognize same-sex marriage from other states. And we were in court in less than a week after that meeting. And I knew that by their decision to challenge Ohio's constitution, that the argument had to be directed to the jurisprudence that had been established by Justice Kennedy. We have 9 members on the U.S. Supreme Court. And at the time, Justice Kennedy had been very instrumental in advancing gay rights. And it was his decisions, his majority opinion, that had really pushed the ball forward. Back in 2003, he had written the decision in Lawrence versus Texas, which struck down the sodomy law in Texas, and it made same-sex sexual activity legal nationwide. And of course, he was the one who wrote the decision in Windsor, which struck down Section 3 of the Defense of Marriage Act. He was also in the majority in Romer versus Evans, which struck down Colorado's Amendment 2, and that forbade laws protecting LGBTQI individuals from discrimination. So he was a really important person, and his thinking was something we had to really pursue. And I brought our case with this precedent in mind. One example that I always used was that in Ohio, you couldn't marry your first cousin. But if you go to Georgia, where you could marry your first cousin, and then return to Ohio, Ohio would recognize that marriage. So I argued under our Equal Protection Clause that same-sex couples were being treated, differently with no valid purpose than first cousin couples. And that was part of the argument that we pursued. So I went to court. We won in the district court, and unfortunately, John died not too long after that. And the state of Ohio did issue a death certificate for John that listed him as married and listed Jim as a surviving spouse. But in the same breath, the state of Ohio said, we are going to change this death certificate back if you lose this case. So it kept our case alive. We went to the Sixth Circuit Court of Appeals, which is the appellate court over Ohio, and argued, and we lost in the Sixth Circuit. The court said, marriage is something we should just leave up to the people of the state. And their argument was we should leave it up to what they called the democratic process. And they just didn't think that courts should determine who had the right to marry and who didn't. And because we lost in the Sixth Circuit, the U.S. Supreme Court was the next step. And we went on to take the case to the U.S. Supreme Court. And there were two questions in the U.S. Supreme Court, the right to marry and marriage recognition. And as Carlin mentioned, when we first brought the Obergefell case, there was a lot of concern in the gay rights community that this wasn't the argument we want to be pushing. They had been litigating cases in a very strategic manner where they were forcing states to pursue and adopt a right to marry, that people be allowed to marry. And of course, that's the gold standard. If you're allowed to marry, of course, in that state, they'll recognize marriages from other states. But in our situation in Ohio, where our own state constitution prohibited gay marriage, we felt that it was also important to separately pursue what we call marriage recognition. The argument that even if Ohio doesn't, excuse me, doesn't allow gay marriage, they still have to recognize gay marriages from other states, and that this would be something that would advance the ball. And while some organizations opposed this approach, we pursued it, and both questions were presented to the Supreme Court. Now, as you know, the U.S. Supreme Court in a 5-4 decision recognized gay marriage in the Obergefell case. And it said directly that this marriage is a fundamental right. And they're not going to leave it to the democratic process. They're not going to say that your right to marry should depend on whether the majority of the public votes for it in one state or another. And they said that this fundamental right is central to individual dignity. It's central to our role as building families and protecting children, and that to ban same-sex marriage and marriage recognition would violate our guarantee of equal protection in the U.S. Constitution. But they knew that there were to be a lot of people that would oppose gay marriage on religious grounds. And the court was careful, even in the initial decision, to say that people can still disagree with what we're saying, that there will be a right to speak out about your beliefs, but the government will recognize gay marriage. So also in the majority decision, they recognized and granted our a favorable decision on our issue. And they said, as is made clear by the case of Obergefell and Arthur, the recognition bans inflict substantial and continuing harm on same-sex couples. So even in the majority decision, they recognized the importance of recognizing marriages from other states. And this became a separate leg, a separate basis for the decision. And this becomes really important as we move forward and answer the question that was posed to me: what is the future of gay marriage? Now, you know, you have to look at this one excerpt from the decision. No union is more profound than marriage. It includes the highest ideals of love, fidelity, devotion, and sacrifice, and family. In forming a marital union, two people become something greater than once they were. I think that sentence from the majority decision has been included in every gay marriage that has occurred in the last 10 years. And Jim Obergefell, my friend, who I continue to have lots of contact with, has presided personally at over 300 same-sex marriages, and he assures me that that sentence is included in almost every gay marriage ceremony. You know, the decision day was a very, very special day. And as we see the dark clouds arising around us in terms of all these rights, it's good to remember what a celebration we had 10 years ago on the steps of the Supreme Court. In fact, when I broke away from the celebration on the Supreme Court steps, I called the mayor of Cincinnati, John Cranley, and I told him that my law partner and I had 5 couples who were prepared to get married that very day. And we had worked it out with a Republican probate judge who kind of knew that this ruling would occur to issue marriage licenses, even though the case had not been sent back to the district court. So marriage licenses were issued. Those 5 couples gathered on Fountain Square in Cincinnati, and they were all married on decision day in a great celebration that very day. We returned to Cincinnati the next day, and it happened to be Gay Pride Day. So we were in the middle of the parade and continuing the celebration. But there was a dissent, and that dissent was signed on by 4 of the justices of the Supreme Court. And 2 of them were pretty scathing. They said that this decision was simply enacting a policy preference as law, and rather we should be leaving the issue of gay marriage to the democratic process. And again, the majority said, no, this is a fundamental right. We don't let that be voted on. We recognize it and protect it, because minorities who will never have majority support deserve that kind of protection by law in a country that is run by the rule of law. Justice Thomas said that the liberty protected in the 14th Amendment is a right to be free from governmental action. And he thought that the majority decision instead was proactive, and it granted rights and benefits that the court had no business doing. And Justice Alito said that marriage was linked to procreation, and that gay marriage had no place in that construct. And he also warned that just because you oppose gay marriage doesn't mean you're a bigot. We had our first test of whether Obergefell would hold up in a case that came along 2 years later. And this was Pavin versus Smith. And what was really interesting is that I did a couple of companion cases along with Obergefell. One of them was IVF. We represented 5 different lesbian couples who had become pregnant using in vitro fertilization. And we argued that if you look at Ohio law that required the state to put the husband's name on the birth certificate of an IVF baby, if there's an opposite sex couple, then the same thing should apply if you have a same-sex couple, so that the same-sex partner should be on the birth certificate when the other partner gives birth. And Ohio had said no, and we were litigating that case at the same time as Obergefell. Our district court said, yes, we were right, that this was a natural consequence of the Obergefell decision. This case was decided in a 6-3 vote. And what's interesting is that they used the same reasoning we had used and said that this was part of the rights that come with marriage. And if a state law is going to require that the husband in an opposite sex marriage has his name on an IVF baby's birth certificate, the same should hold for a same-sex marriage. I will note, though, that even in dissent, no one called for the reversal of Obergefell. They simply said that IVF was not one of the rights that flowed from the Obergefell decision. So that was not viewed as something, as an opportunity to start the process of reversing Obergefell. But then Kennedy, the justice that I talked about as being so important to gay rights, resigned from the court on June 27, 2018. And in 2022, the court heard the case of Dobbs versus Jackson's Women's Health. This was an abortion decision that reversed the right to abortion, Roe v. Wade from 1973. And what it did is it said that the right to privacy did not include the right to by a woman to terminate a pregnancy, which was a huge change in the law for the United States and a tremendous setback for women's rights. And Justice Thomas shot that ammunition across the bow in his concurring opinion, which I quote, "We should reconsider all of this court's substantive due process precedents, including Griswold, Lawrence, and Obergefell." So Griswold was the case that established a right to contraception, and that used due process, also in the 14th Amendment. Lawrence, as I mentioned earlier, was a case that struck down Texas sodomy law and said that same-sex couples have a right to privacy in their own bedrooms. And of course, Obergefell was our gay rights decision establishing gay marriage. And here was a Supreme Court justice calling for all of those cases to be reversed. And it did send a chill through those of us in the advocacy community saying, what could we do to further cement the rights that had been established in Obergefell? Well, especially as I speak to you now, of course, the federal government is shut down because of the complete dysfunction of Congress and the executive branch. But back in 2022, they were capable of actually doing something positive, and that was the Respect for Marriage Act. This law was passed by Congress and signed by President Biden on December 13th, 2022, just 6 months after, or 5 months after the Dobbs decision in the Supreme Court. And what it did is it made some findings, first of all. And it said that it wanted to repeal the Defense of Marriage Act, which was the law that had been partially struck down in Windsor, while also respecting the role of states in the regulation of marriage, because it knew that this was the trick. Somehow we want to protect gay marriage, but we want to respect the role of states. So they made some findings. They took that first sentence, which is in the decision that I read to you and is in all those gay marriage ceremonies about how profound marriage is, and said that's a finding, that's important. And we wanted to promote the ideal of love, fidelity, devotion, sacrifice, and family. And it also wanted to recognize the diverse beliefs about the role of gender in marriage. So it wanted to recognize that people could disagree, and it affirmed people's right to disagree about the role of gender in marriage. But then it went on to say millions of people are getting married, and it includes interracial marriage here. And they have a right to stability in their marriages. Couples joining in marriage deserve to have the dignity, stability, and ongoing protection that marriages afford to families and children. So what does this mean? Well, my case was a great example because Cincinnati, where I practiced law and where the Obergefell case originated, is right on the Ohio River, and right across the river is a state, Kentucky. And the notion that every time a Kentucky same-sex couple would go into Ohio and their marriage wouldn't be recognized, but then if they go back to Kentucky, their marriage might be recognized, was untenable. We have 50 states with boundaries all over the place. And this finding was a recognition that you've got to have stability if you're going to have marriages and families and children, medical decisions, financial decisions. And that's an important part of the finding in this Respect for Marriage Act. So what the act actually did is it repealed the rest of the Defense of Marriage Act, and it prohibited states from refusing to recognize same-sex marriages validly entered into in a different state. So that just like Obergefell and Arthur, they came back from Maryland where their marriage was recognized. As long as it was valid in Maryland, it was going to be valid in Ohio under this law. And that's a big deal. But it gave a concession. It said the federal government would no longer be in the business of deciding what marriages are valid. It would only require recognition. And then the big giveaway was that it said states did not have to perform same-sex marriages if they didn't want to. So it split the right to marry from marriage recognition. And as a principled matter, you could say this doesn't make much sense. Because if there's a fundamental right to marry in the Supreme Court, then it should exist in all the states. But what this was is a backup plan, much like my lawsuit was. If the Obergefell decision is reversed, like Dodd's was, reversing Roe v. Wade, this federal law said we will not impose the duty to perform marriages on the states, but we will say they have to recognize marriages from other states. And to further give you an example of how this was a negotiated political solution, one of the most conservative religious groups, the Mormons, the Church of the Latter-day Saints, supported the bill because they saw it as a reasonable compromise. As long as states like Utah were not required to perform gay marriages, they saw the practicality of recognizing marriages from other states. And this helped get the law passed. And now that law is the law of the land. So same-sex marriages are authorized state by state, and that will continue to be the case. And all the federal law does is say that each state isn't required to marry same-sex couples. They'll leave that up to the state itself, but requiring states, but it does require that they recognize marriages from other states where it's legal. So where does that leave us? What if the Respect for Marriage Act itself, that statute, was repealed? And what if Obergefell gets reversed? Then where are we? Well, we have some options. The first thing is rely on state constitutions. Every one of the 50 United States has its own state constitution. And every constitution is interpreted by that state's Supreme Court. That state Supreme Court is the ultimate voice on interpreting that state constitution. But if the state constitution itself includes a marriage ban, a gay marriage ban, then we're in trouble. So back in 2004, when the Republicans were worried that they might be at risk of losing the presidency to John Kerry, the Republican Party promoted a bunch of state constitutional amendments, 11 different states and critical states, put on the ballot at the same time as the presidential election, these same-sex marriage bans. Like in Ohio was one of those states. So in Ohio and in several other states, the state constitution was amended to say that marriage has to be only between a man and a woman. That state constitutional term or measure is unconstitutional under the federal constitution after Obergefell. But if Obergefell is reversed, that becomes the law in that state again. So there are some states where it will remain legal, even if the federal law, the Respect for Marriage Act, and Obergefell are reversed. That's California, New York, Maine, Minnesota, Vermont, Connecticut, Iowa. Those states will have gay marriage that will be legal under the state law. But other states, like Ohio, which have the gay marriage ban in their constitution, will automatically revert to having gay marriage ban, except if the constitution of that state or any of these states were to be reversed. And you know, when I say reversed, I mean that provision repealed. Let me just speak to that for a second, because I was very involved in Ohio after the Dodds decision. And at that point, abortion was illegal in Ohio as a result of the reversal of Roe v. Wade. And many people organized in the state of Ohio to amend the state constitution to protect abortion. And a lot of people thought Ohio's what they call a red state. It's very conservative. This won't pass. But in fact, the measure did pass by a pretty strong majority. And voters across Ohio amended the state constitution to protect the right to abortion. So it's not unheard of that people could organize in states and reverse the marriage bans that were imposed as a result of the 2004 initiatives that I described earlier. Now, in states that don't have marriage bans built into their constitution, there could be state laws that protect the right to marry and the duty to recognize marriages. But these are the avenues for advocacy should both things happen. But then so right now there is no active movement to repeal the Respect for Marriage Act that requires the recognition of marriages from other states. There is an effort to reverse Obergefell, and that's being pursued by Kim Davis. And Kim Davis is another person a case arose right across the river from where I practice law. She was a county clerk in a Kentucky county, and she, right after the Obergefell decision, she refused to issue a marriage license. And there were several couples that did not get a marriage license. So she was an official. They sued, and the court held that that she cannot use her own constitutional rights, and she's saying this violated her religious rights, to violate the constitutional rights of others when she's performing her duties as an elected official. The court basically held that she can't turn her religious views into the law of that county. So the case got very complicated. It went to the Supreme Court early on. They refused to take it. She was ordered to issue the marriage licenses, and then she was sued for damages. And she was actually ordered to pay $100,000 in damages, plus a couple $100,000 in attorney fees. That is the ruling that's currently on appeal. Her loss and the order to pay damages was affirmed by the Sixth Circuit Court of Appeals, the same court that didn't want to recognize the right to marry. And now she's got a what's called a cert petition pending in the U.S. Supreme Court. And as part of one of the questions that she has posed to the court is that they should reverse Obergefell. Of course, if they reversed Obergefell, then she claims that that would mean that her whole damage verdict would be gone and she would be free of that responsibility. The court has not ruled yet on her request to be heard, but most of us believe she has a very low chance of prevailing. And it goes back to Justice Kennedy again. If we go back to the Obergefell decision itself, you see that he anticipated this problem. And he said, when sincere personal opposition becomes enacted law and public policy, that puts the imprimatur of the state itself and denies liberty to same-sex couples. So he's already said in the Obergefell decision that what Ken Davis tried to do cannot be done. And that we hope will continue and they'll turn down his case. But another person who's challenging, who challenged the reach of Obergefell was Lori Smith. And it wasn't directly on point, but it started this, what she hopes, I'm sure, is a whittling away of gay rights in America. She ran a website design effort, and she wanted to be available to people who had weddings that they celebrated. But she's a Christian, and she didn't want to serve same-sex couples. Colorado has a public accommodation law that says you can't discriminate based on sexual orientation. The court held that in her case, she could refuse to serve same-sex couples because it violated her religious beliefs. And this was a narrowing of what we believe ought to be the reach of Obergefell and of gay rights generally. And it actually was quite a bit different than another case the Supreme Court decided in 2020. Again, this was after Kennedy had retired. The Bostock case. Now, this was a big deal. We have a law, Title VII of the Civil Rights Act of 1964, that says you can't discriminate based on sex. And in Bostock, the U.S. Supreme Court interpreted our sex discrimination ban to include sexual orientation and gender identity. So that means employers can't discriminate based on sexual orientation or gender identity. And that's the federal law, and it applies to any employer with 15 or more employees. Given that interpretation of federal law, it was disappointing that they gave an exception to the Colorado public accommodation law. But right now, Bostock is the law of the land when it comes to large employers. But what if you have an employee? What if you employ less than 15 people? Well, only 22 states ban sexual orientation or gender identity discrimination in employment. And most states actually have no protection against sexual orientation or gender identity discrimination in housing, public accommodations, and employment. So there's a great challenge, a lot of work to be done. The notion is that the because of sex terminology in Title VII, and that should also exist in these state laws, should be interpreted as it was in Boston to include sexual orientation and gender identity. And you're going to see in a minute why that argument is really important in a pending case before the Supreme Court. Now, I've talked about the future of gay marriage. I think it's pretty secure right now, given the backup plan with the federal statute, and the opportunity to protect it among the states. But I do want to touch on the assault on gender identity and gay rights that the Trump administration has commenced in the last 6 months. We've seen it in sports, in military, medical care, bathrooms, access to books. And this is all based on a series of executive orders that the Trump administration issued in January and February of 2025, right after he took office. Now, I will note that the majority of his targeting of queer folks is focused on trans people. And that's disgusting and revolting. But he doesn't seem to be attacking gay people generally. In fact, his Secretary of the Treasury is an openly gay man married to an attorney named John Freeman, and the two of them have a child through surrogacy. So I don't see the Trump administration trying to take on gay people as a group. He's really peeled off one of the most vulnerable and the groups that need protection, trans people, and kind of using them as the punching bag. And you'll see this particularly, notice that he's got his trans ban in the military. Previously gays were banned from the military. Now he's just banned trans people. In addition to these executive orders, though, which go a really long way in rolling back rights for trans people in particular, he repealed all of President Biden's executive orders that protected LGBT rights. And as you can see, that's a real problem. Title IX is to sports and to education what Title VII is to employment rights. And President Biden, following the Bostock case that I just talked about in employment, said, well, I'm going to interpret sex in Title IX to include sexual orientation and gender identity. And Trump has reversed those executive orders. So now, when we look at Title IX and its impact on education, and we look at Title IX as an impact on sports and schools, we have a federal interpretation that says that trans people, gay people, are not protected by Title IX. And we have states that are bucking it. I'm using Minnesota as an example, for example. Minnesota still lets trans girls play sports and based on their gender identity. And the Trump administration has sued Minnesota to end that practice. The state has won an injunction against Trump administration at the trial level, and now that's on appeal. But the whole question is going to be decided this term, which means sometime before July 4th, usually, of 2026, by the U.S. Supreme Court. There are two cases involving trans athletes pending in the U.S. Supreme Court. One involves the Idaho law, and one involves the West Virginia law. And these statutes basically require that the states not permit trans women and girls from playing on women's teams. And they go back to this interpretation that sex is got to be determined, as they call biological sex, the sex assigned at birth. The lower courts have held that these laws violate Title IX and the right to equal protection. And so the trans athletes have prevailed so far. The interpretation of Title IX, if we're going to follow Basta, makes sense. And the application of equal protection to this would also make sense. But stay tuned to see what the Supreme Court may do. And as you'll see in a second, we may have some hint of that from the gender affirming care case that I'll talk about. Another case that's percolating across the country, another issue, is the access by trans people to bathrooms. And the executive orders say that you have to use bathrooms consistent with the biological sex assigned at birth. And lots of different cases have litigated that. But there's one case out of South Carolina brought by a single individual, a person named Doe, where the court protected that trans person's right to use the bathroom of the gender that he identifies with. And the court affirmed that there's a special way that people go to the Supreme Court these days called the emergency docket or the shadow docket. And at least in that case, the Supreme Court let the injunction protecting John Doe stay in place. So I don't really have a lot of hope that that is going to continue as this litigation proceeds. Gender affirming care was decided in June of 2025 in the United States versus Scrimetti case. And that was a classic application of equal protection. The proponents said that the state ban on puberty blockers and hormone therapy for minors violated the equal protection rights of trans people. And they tried to use a higher standard to assess the challenge, which is the sex discrimination standard, which is intermediate scrutiny. Under intermediate scrutiny, you have to show that the governmental purpose substantially supports the classification. Well, the court didn't buy that. The court said, well, this isn't really a gender classification, it's an age classification. And any basis that the state wants to put out will justify their ban of gender affirming care. So the court permitted Tennessee to ban gender affirming care. And of course, now, just like in abortion, we have a situation where there are a majority of states, that like 33 states, that ban gender affirming care. And we have only 14 states relying on their state laws that promote or permit and protect gender affirming care. And the keys to this map don't match the next one, but I'll just say that this shows you that there's a group of states in the North and the West that protect women's rights on abortion, and that's here. You see these blue states, and they're the same states that protect gender affirming care. So all that does is show that as a nation, the United States is becoming very polarized around these important fundamental rights that are presented by the issues of abortion and gender affirming care. Now, I did mention that the executive order prohibits transgender people in the military, and the Supreme Court has lifted the injunctions on that executive order, and it is being implemented as we speak. About 1,000 people have been separated from the service, and it may go up to 5,000 people by the time this gets fully implemented. But it does not, as I mentioned, apply to gay people generally, just trans people. There's also litigation around identity documents. The Trump executive orders say that the passport should reflect biological sex at birth. But in Orr versus Trump, which is a class action, the court enjoined that and said that trans people have a right to have their gender identity, an X marker, that it violates equal protection to deny that right, that it reflects an animus or an attitude, a negative attitude toward trans and binary people, and it's struck down and enjoying the Trump effort. We also have ongoing litigation that I'm involved with at the state level to where people like coming to Minnesota, for example, and they have like a birth certificate that says they're a boy, but now after their gender identity is established, they want that birth certificate amended to say that they are the opposite gender. So we're litigating under pretty arcane state laws to require birth certificates to be amended to conform with people's gender identity, and that's an ongoing effort. A related case that came out in June of 2025 is the book banning case. It's not really a book ban, it's more like a hyper concession to parental rights. In Maryland, there was a school district that had books that wanted to support a welcoming attitude to minority couples, people who were LGBT, same-sex couples, and they had picked some books that responsibly introduced people to these types of parents. But parents of Christian families and others with religious objections sued, saying that they needed to have a right to remove their children from that kind of instruction, which is just create chaos in the school system. But the court agreed with that, and it recognized that parents would have this right to pick and choose to what their kids would be taught in public school if it touched on their rights, which is a real problem if you want to be an inclusive country or community. So the other issue that is now before the Supreme Court that relates is conversion therapy. Conversion therapy, of course, is where therapists try to convince a person that they, even though they think that they are of another gender, that can't be true, or of another sexual orientation, that can't be true, and they try to convince them to convert back to the sex assigned at birth and or their gender identity. And the lower courts did not strike down this law. The Colorado law bans conversion therapy based on many different studies that say it's not appropriate and that it harms people. But that case was just argued in the U.S. Supreme Court, and the challenge is grounded in the First Amendment. Talk therapists, and the plaintiff is a talk therapist, say that this denies them their right to free speech. And that seemed to carry some weight by the Supreme Court. So I don't know how that case will turn out, but I would caution that the result in this case may not actually mean that much for gay rights, because it may stem more from the way the conversion therapy ban is described under Colorado law, which is sort of vague, and it may be susceptible to a First Amendment challenge. Another area is with respect to queer immigrants. So far, we haven't seen any rollback. If you're a same-sex couple, you're afforded equal rights in America, in the United States, when you petition for spousal benefits, for fiancé visas. So we haven't seen any actual rollback on that yet. But we caution that, the actual treatment of same-sex couples may vary because of enforcement. Now, I am not an expert in international human rights, but I do note that even though we are under assault here in the United States, same-sex marriage is legal in 38 countries. And that means that it's not legal, and in fact banned in almost 157 countries. So obviously there's a tremendous amount of work to be done with respect to what we can do to expand it. The Americas, are doing pretty good when it comes to this, and that's because the Inter-American Court of Human Rights has issued some rulings that support gay marriage. In Europe, the European Court of Human Rights has also issued rulings that support gay marriage. At the UN itself, sitting in New York, gay marriage is recognized on its staff, and benefits are extended to its staff. So there's great work being done to promote gay marriage internationally. Back in the United States, there is a number of things that are being done to challenge this effort to roll back gay marriage and to roll back trans rights. 19 different states have sued to block Trump's attack on trans people, and those are working their way through the courts, and there have been injunctions. The arguments are that this is viewpoint discrimination under the First Amendment, that his bans are vague, and that they violate administrative law. And there's also been some lawyers and law firms that I just want to mention. Some people at great risk to themselves have stood up and done the right thing. So, for example, President Trump ordered that the corruption charges against the mayor of New York, Eric Adams, be dismissed. 6 different persons employed at the Department of Justice resigned, rather than, they gave up their whole careers rather than follow that order. Similarly, when the former head of the FBI was recently indicted, a career prosecutor who had worked for the Department of Justice for decades resigned rather than indict James Comey, because he didn't believe that it really met the standards and that Trump was just being vindictive. So, and then Trump has also gone after law firms. So I suppose it kind of shows that law firms are more businesses these days than many times the principal efforts that we thought they were. But at any rate, he's threatened to revoke security clearances, deny federal contracts, and penalize firms that represent clients that are critical of Trump. And many have buckled, and they've agreed to provide pro bono work. They've donated money to things that Trump wanted them to donate to. And a lot of us think that this is a violation of ethical rules that guide lawyers. And it's a real sore spot in our profession right now. Similarly, he's gone after colleges and universities, and he's just proposed what he calls the compact for academic excellence, which would severely restrain free speech on campuses. And so far, MIT, Brown, University of Pennsylvania, University of Southern California, and the University of Virginia have all rejected this compact. And they're going to risk losing federal money as a result. Harvard had an early confrontation with Trump and is in the middle of litigation against him. But this is another effort to use some of the thought leaders in this country to adopt things that the administration wants to pursue, including rolling back the rights of gay people and trans people. So at an individual level, when we get to just the idea of what we can do, I want to underscore the power of local advocacy. Everything I've done was done locally first. The city of Cincinnati was a microcosm of the nation. I was able to bring trans discrimination cases in Cincinnati. I was able to bring cases that challenged statutes that restricted the rights of gays. And, you know, as we look locally, we have many opportunities to promote the rights of gay people. And this is actually, Cincinnati is centered. I think Carlin mentioned the Netflix series Amend, which is out and is on Netflix. And episode 5 is called Love. And it tells the story of Cincinnati moving from an island of hate as one community in America to becoming much more welcoming through not only our litigation, but the public advocacy of many people throughout the city. Nationally, you should tell your legislators, if you are in the states, to pass the Federal Equality Act, which would prohibit discrimination against gay people in employment, housing, education, and public accommodations. We also all need to celebrate and support those who would quit or be fired rather than abide by anti-DEI or transphobic orders. And we need to speak up and write and promote positive images of gay people and trans people. And again, these can be locally done. I just finished a case in Colorado where a sorority refused to admit a trans woman because they said, well, we're just for women and you're not a woman. And so I represented a group of what are called amicus, friends of the court. And we collected all the different arguments for why trans women are women and included an appendix that showed multiple examples of how trans people are depicted favorably in the arts and in books and in across America. And I can't underscore enough how important it is that books and movies and songs and the arts favorably depict trans people and others who are being targeted, because it does change public opinion. I can attest to that because I have picked juries over 40 years. And when I first started picking juries for trans people, they wouldn't even want to be in the same room as my client. And now many people are familiar with trans people and have one or more in their family. So we are making a difference. And finally, remember I told you about the 5 couples. Well, consistent with this call to positively promote trans people and gay people, Cincinnati has just this week unveiled this mural celebrating the 5 marriages on Fountain Square 10 years ago. Well, let's talk. What questions do you have?
Well, thank you so much, Mr. Gerhardstein, for a very informative talk. It does sound like we have a series of cases on both the Supreme Court and circuit level that are challenging many aspects of our LGBTQ rights and some of the rights that seems pretty fundamental to human rights, but we'll see how that goes. Now I would like to invite some of our audiences to post their live questions to you and hope that you can help answer some of those questions. The first one is Michael Wren. Would you like to read out your question to Mr. Gerhardstein?
Hello, can you hear me?
Yep.
Yes, and this is Miko from China, and thank you for your extraordinary efforts in your career and in your the same-sex marriage. And I'm currently engaged in interdisciplinary research at the intersection of literature and law, focusing on Margaret Atwood, the Canadian author, Handmaid's Tale, and the Testaments. By comparison, the Dobbs you must mention and the Morgenthau in Canada, I have come to realize that such a ruling result is far from an isolated event. Rather, it appears to be an inevitable outcome of a long-standing conservative policy in the Trump administration. Moreover, this restriction on bodily autonomy and gender freedom is likely to extend to other gender-related rights, such as those of LGBTQIA+ community. So, given in this context, I was wondering whether you can provide a in-depth analysis of the Dobbs case to help us better understand this decision-making process, potential ramifications, and the underlying factors that contribute to this outcome. I mean, the immediate result is kind of obvious. It's so-called trigger laws. States like Mississippi, Arizona just almost completely banned abortion at any time. And I just wondering, will this be any more further results of this decision? And you just mentioned we need more trans literature and books. So I wondering if you think the literature has its own agency in focusing or enforcing or enlightening or fostering the law to change from what we call state-posed utilitarianist law to the kind of natural or more human-centered law. This is my question. Thank you.
Well, thank you for that question. And let's talk about Dobbs first. It reversed Roe v. Wade by attacking the rationale in Roe. Roe recognized a right of privacy, and the right of privacy is not explicit in the Constitution. So this ruling arises from an ongoing debate among constitutional scholars about whether you are an originalist and therefore you're looking for a right that was present when the 14th Amendment was passed or the country was founded, or whether you're looking for a right that naturally flows organically from our growth as a nation and our growth as a country ruled by law. And those of us who believe in an organic constitution have no problem with the identification of the right of privacy. But there was another alternative. There were many people who believed that abortion rights should be viewed either under the First Amendment as banning abortion would be an expression of religious right, which is a viable argument, or under the Equal Protection Clause, saying that regulating abortion was imposing more rights on that medical procedure than comparable medical procedure. Neither of those theories was ever pursued, and in fact, Justice Ginsburg later criticized Roe herself by saying that maybe the rationale left the decision vulnerable. And I am less convinced than you suggest in your question that because Dobbs was decided, Obergefell is equally at risk. Because in his majority decision itself, Alito and Dobbs, Alito says that this decision applies only to abortion, which involves the life of a fetus. So it was clear that the majority in Dobbs were reaching out to protect this unborn potential life. And that type of argument just doesn't exist when you're dealing with gay rights, transgender rights, and so on. And it is a line that can be drawn and may stop what might otherwise be seen as a trend. Now, that doesn't mean that I'm confident that Obergefell is secure. That's why the federal law, the statute, the Respect for Marriage Act was passed in 2022 to be a backup should the court reverse Obergefell. But Obergefell was not decided on the same basis as Roe v. Wade. Obergefell did recognize a due process right to same-sex marriage, but it also recognized an equal protection. And that equal protection argument is missing from Roe v. Wade. So doctrinally, I see a much more robust basis in Obergefell than was present in Roe. I wish that the Supreme Court could be persuaded by the rationality of all these arguments, and that was the end of the debate. But it's clear that personal passions, public opinion, other things are at play, and I don't know for sure that Obergefell will survive, but at least in distinguishing it from Dobbs, that's the reason I don't think it's automatic anyway, that we're on the slippery slope. Does that answer the question?
I think it was a very holistic review. Yes, Michael. Michael.
Yeah, thank you so much.
Great, thank you. The next question is from Yixing Zhou. Would you like to raise your question?
Okay. Thank you for your sharing. I'm from China and I'm a lesbian. I often hear such questions like this. Since heterosexuals are already opposing marriage, why do we homosexuals want to enter into marriage? The legalization of same-sex marriage not only benefits the homosexual group, but does it also have any advantage for other groups, especially for the heterosexual group?
So the question is, help me out. Do I agree that recognizing gay marriage that helps opposite sex couples? I mean, I would say so. I mean, if you look at, if that's the question, if you study the Obergefell decision and you read the Lawrence decision from Kennedy, the Obergefell decision from Kennedy, the Loser decision from Kennedy, you know, he often references children. And he talks about how the government should support a family structure that enables the best environment for stability in a child's life. And basically saying you can never have too much love to surround a child. And so in that sense, I totally agree that opposite sex couples are served by the recognition of same-sex marriage, because it's all based on something that all couples share in terms of the commitment to their personal autonomy, and to those who have children, supporting their role as parents. And I think the court decisions reflect that.
Great, thank you very much. We'll move on to the next question from Yuxing.
Hi, thank you so much, Mr. Gerhardstein, for your entire effort and the momentary and legendary moment in 2015 that was so significant. So thank you so much. It was a game changer for a lot of our lives. On top of the historical truths which happened, I'm wondering what are your thoughts on the so-called post-gay era that is described by a lot of the queer activists, meaning that the marriage is sometimes criticized as heteronormative or overly institutionalized. And based on your experience in practicing the law, what are some of the aspects or the reality that you see that make you still believe that marriage law remains highly important and relevant today? And also on top of that, do you see any other legal forms or policy change that are emerging and you find exciting, or the new opportunities that are on the horizon? Thank you so much.
Well, thank you. The centering of marriage in the expanded rights of the LGBTQI community is deliberate. I will tell you that when we were prepping and doing our moot court arguments for the Supreme Court, one of the biggest things that people were worried about was the movement for marriages that include multiple couples, or bigamous and polyamorous people, and we discourage proactively moving into those discussions. And as we practiced responses, we kept coming back to at least the legal norms around marriage itself. It is so critical to the family and to domestic law in the country. Now, does that mean that there's no legal basis for some of these alternative arrangements? No, it just simply means that the law moves a lot slower than society. And at one point, it would have been scandalous to suggest that a black and a white, a black woman and a white male would get married, and the law caught it. Another point, it was gay marriage, and the law caught it. So maybe as society becomes more comfortable with alternative arrangements, that it'll continue to support those arrangements, or it'll expand to support those arrangements. But right now, even as you're talking to a progressive civil rights lawyer, I will tell you that the law is conservative. We are trying to cement our commitment to full embracement of non-traditional marriage, non-marriage from same-sex couples into the mainstream. The next round will have to be done after that's fully achieved, and right now we're just not there. I would
Thank you
say
so much.
none of the arguments we've used would exclude alternative arrangements for life and love. So, maybe someday those arrangements will be lifted up in something, even in the law.
Great, thank you. The next question orders from June Zhu. Would you like to unmute?
Hi, thanks for your sharing, and I'm really appreciate for your contribution to the same-sex marriage and the protection for the LGBTQ equal rights. So, from your speaking, and we can discover that, well, the Trump government has enlarged the coverage of religions exemptions for to refuse providing services for same-sex wedding, abortion, and transgender affirming therapy. And there is the same trend in UK, but operating another way. Like the conservative forces, they tend to restrict the transgender rights in the name of philosophical belief. They say that like the gender critique ideology is a kind of philosophical belief, so they can deny they can misgender transgender people, and they can deny the equal rights of transgender people, and it also influence like the participation of transgender women in military, in sports, and even in single-sex spaces. So it seems that the logic is like the legal rights, the legal protection of anti-discrimination rights, and even the body autonomy for LGBTQ people should be subordinated to the free speech and religions and philosophical beliefs of the conservative mainstream. So I wonder, how can LGBTQ people reclaim their equal rights and equal citizenship under those situations?
Well, remember that the conservatives lost around in Boston. In that case, I know that there will be efforts to limit its application. But that applies to every employer, 15 employees or more. And Title VII prohibits discrimination because of sex. In that decision, the Supreme Court interpreted because of sex to include sexual orientation and gender identity. And that's 2020 decision. I mean, no, they're not going to reverse that quickly. So they're boxed in to a certain extent. And this was a ruling from pretty much the same Supreme Court we have now. I mean, it's after Kennedy, and it's with a lot of the same, that Gorsuch wrote the decision. And they've come up with a ruling that doesn't fit the conservative ideology that you're describing. Now, that doesn't mean that the conservative ideologies won't carry the day in other contexts. I already described the argument in Scrimeti and the gender affirming care case. The argument in the case involving public schools and the distribution of books about the people. And so where they can, you're right, there will be some effort to rein in the expansive application of equal protection and anti-discrimination law. But Bostic is going to be a cornerstone for us, for those of us fighting this battle, to continue to fight and hopefully build them even through the Trump years. And remember the charts I put up, how polarized the nation is, with state laws protecting gender affirming care and abortion rights, all centered in the northern and western states. And there's going to be a strong movement to push back on any of this conservative argument that will continue to be pursued. And we might see the entire nation swing strong, like it did when it elected Obama, and then he appointed judges and Biden. So I'm an optimist. I believe in the rule of law, and I believe that we can influence the rule of law by continuing to lift up those decisions that most embrace our history of equal protection and the rights of the individual.
Great, thank you. It's hard to stay optimistic during our current situation, but it is always good to have hope. Our next question is from Sia.
Oh, yes, can you hear me? Yeah, okay.
Yes.
Yeah, thank you so much, Ms. Gerhardstein, and for your presentation and for all the efforts and difference you have made so far. So this is based my personal observations, because we always group like LGBTQ plus communities together, that when it comes to the queer rights. But in reality, based on my personal feeling, I feel like the transgender seems to be more vulnerable and more invisible when it comes to some very practical rights. And we also bring up some examples like the access to bathroom, etc. So I found what's ironic is that some people are strongly staying together with LGBT rights, but are harshly against the transgender groups. So maybe they hold the belief that, oh, the biological sex at birth is as holy as one's natural sexual orientation, whatever. So this brings me a very difficult questions. Do you think the resources and rights among these minority groups are so limited that they have to fight each other, that they become inversely related and forcing them to compete against each other? Or on a higher level, do you think the fact that some minorities groups, they reclaiming their legitimate rights that has been held by the majorities for a long time truly harm and hurt the existing lawful interests and rights of those individuals from the majorities? I just wonder, just forget about the abortion, just talking about individual, very practical rights in reality.
Well, let's remember our history a little bit. When I was doing the initial trans cases back in the 90s and the early 2000s, I was doing those cases as a private attorney. Why is that? Well, partly because I had the clients, but I was doing them alone, and the major organizations didn't care about trans people. I mean, Human Rights Campaign didn't attend to trans people. Lambda wasn't involved with trans people. I mean, it was a NCDR, GLAD. These were all groups that largely were focused on gay people. And trans were having mentioned. Now, I see a tremendous change in that commitment. And I'm incredibly impressed by the resources and the legal commitment that is being made on behalf of trans people, not only in all those organizations, but even by mainstream governmental organizations. 19 attorneys general from across the country have filed lawsuits seeking to protect trans people. That's just about all the Democratic attorney general. I just don't think that we are currently in a period when, in order to protect themselves, gay people are tossing trans people over the boat. I think that right now, especially in the legal arguments where I and legal organizations that I'm part of, trans people are fully embraced, fully supported, and you know, folks are rallying. So I hope I'm right, but I don't see the division that we once had. So I think maybe your perspective is different from that. But that's what I'm seeing in terms of legal resources here.
Yeah, thank you for your inputs. Yeah, it's great to see a lot of misunderstanding has been clarified, like for the transgender groups. Thank you so much.
Thank you. Our last question is from Yox, but I'm also very curious. It's more on a personal level that last time I saw you, Mr. Gerhardstein, was in 2018. It's been 7 very long years. A lot of things has changed. But we're wondering what made you so driven and keep you motivated during all the controversy to support queer rights agenda? And have you faced any personal struggles and challenges during the time? And what are some strategies to recruit more super allies like you? Because I understand that you've been married for more than 30 years. So we're wondering what on a personal level has kept you going?
Well, I've been married for more than 50 years, but I think that I came of age during the Watergate era, and I was a government student and a student of public policy, and I thought that government, could be used to do good out of the Roosevelt New Deal concepts. And when I was coming of age in law school and saw how much harm government can do, with Nixon having an enemies list and doing retribution and breaking into the offices of those he opposed, breaking into other things. I decided that I would be part of the effort to hold government accountable. And when you hold government accountable, you're naturally going to work with those that government opposes. So I have been working on behalf of prisoners, on behalf of victims of police abuse, on behalf of sexual minorities, and women with respect to reproductive freedom, my whole career. And what's a good thing is that the legal arguments that I utilize, are neutral. They are present. The equal protection notion is available to trans people just like it is to a business person. And I keep reminding courts of it. And it's a very, very strong tool. And that's been rewarding because, of course, we want a nation that embraces everyone and doesn't have an out. So it's been fulfilling, and in that sense, it's been a renewing experience for me to be able to represent people. The other thing that I can say is that when you live in the middle of the country in the United States, and the middle means anywhere from New Jersey to Nevada, you have a lot of opportunity to witness oppression. The coasts are a little more liberal. There's a lot of civil rights lawyers on the coast. There aren't very many civil rights lawyers in cities like Pittsburgh and Cincinnati and Indianapolis and Memphis. And so our work is, I just get a lot of cases, and they're important. And all the major urban and contemporary problems are present in the middle of the country, and the courts are there, and we can use them. So if anyone is a U.S. resident, does choose to become a civil rights lawyer, I highly recommend the middle of the country because we will be teaching.
Amazing. Thank you so much for your holistic review of some of the challenges and the cases we're facing today, and as well as, so selflessly sharing all your experience and wisdoms during your activist and civil rights lawyer career. And we'd like to sincerely hope best wishes to all your future litigations. It is, knowing that there are persons out there like you who are keeping the fight going that really motivates all of us and the younger generation. And we would love to see you as a role model and hope you all the best. And thank you everyone for attending our talk. We're gonna have another talk by Stanford Gender Studies Department former head Professor Estelle Freeman next month on November 14th. We'd love to see you out there again, and keep following us, and we'll keep fighting to make this world a better place for all our sexual minority women and our sexual minority groups. Thank you.
Thank you.
Thank you. Thank you, Mr.
you.
Gerhardstein. Thank you so much for your advocacy and your time. Appreciate that.
Yeah.
Thank you, Colin.
谢谢。Thank you, everyone. Great questions. 非常的开心，大家。我觉得他的这个整个 review of 所有的这些 case，我觉得还是非常的全面的。